The Singapore High Court has ordered Ng Ho Seng, who previously operated under the name Mcase SG, to pay Louis Vuitton manager 900,000 Singapore dollars in statutory damages for trademark infringement. The ruling, delivered by Justice Deder Singjil on 2 July 2025, underscores the judiciary's uncompromising stance on counterfeiting and brand protection. Louis Vuitton discovered in 2022 that Ng was selling counterfeit products, phone cases, watch straps, wallets, and more, bearing the brand's iconic monogram through Instagram accounts Mcase SG, and later Craftsman's SG. After a cease and desist letter in March 2023 failed to stop the activity, the French fashion house initiated legal proceedings in August. Ng did not contest the lawsuit, resulting in a default judgment in November 2023. Instead of proving actual losses, Louis Vuitton opted for statutory damages under Singapore's Trademarks Act. The company proposed 2.9 million Singapore dollars in damages, referencing a Canadian-scale method used in Canada to calculate infringement penalties based on fixed sums adjusted for scope and intent. Louis Vuitton claimed its potential loss could amount to 4.84 million Singapore dollars, but capped the request at 2.9 million Singapore dollars in line with Singapore's statutory limits. Justice Jill rejected the Canadian approach, stating it would overemphasize the claimant's losses, contrary to how Singapore law evaluates statutory damages. The court, he said, must consider multiple factors, including the flagrancy of infringement and the need for deterrence. In his ruling, Justice Jill described Ng's conduct as highly flagrant, highlighting his continued sale of counterfeit goods even after legal warnings. There can be no doubt in the present case that the trademarks used by the defendant on the offending goods are so nearly resembling, if not identical with, the corresponding registered marks so as to be calculated to deceive, he stated. Ng's claim that his products were made from upcycled, genuine materials was dismissed. The judge ruled that such disclaimers were irrelevant in determining whether counterfeit trademarks had been used. Such a disclaimer is an extraneous factor, he said, which has no place in the inquiry into whether a counterfeit trademark has been used. Justice Jill clarified that statutory damages under Singapore law are both compensatory and deterrent. The award should be high enough to deter the defendant and others from committing the same or similar acts of infringement, he noted, adding that repeated use of fake trademarks weakens the exclusivity and prestige of luxury brands like Louis Vuitton. While Louis Vuitton sought a higher cap based on the number of trademarks infringed, the judge ruled that statutory caps apply per type of goods, not per mark. As Ng had sold 9 types of counterfeit goods, the final damages were set at 900,000 Singapore dollars. Ng's persistent non-cooperation and repeated violations aggravated the case. Justice Jill concluded that deterrence must be given full weight under the law. The quantum awarded must be sufficient to signal that such disregard for intellectual property rights will not be tolerated.